First question. Who is responsible for determining a verdict in a criminal trial? Answer down below. The magistrate, the judge, the jury, the defense counsel. Who do we think? I've got one answer so far. Okay. I'll give you guys a bit of time because, again, I think it's a little bit delayed. Okay. We've got a mix. I won't say yet for the people that haven't responded. A bit of a mix. Okay. I'll wait for everyone. I'll give you guys a minute. All right, cool. I think I'm going to, oh, interesting. It's telling me more people have submitted an answer than are watching. I don't know how that's possible. Anyways, let's stop that. I'll stop that. The biggest group was C, which is good because it's the correct answer, and let me explain why. The other big group was between the jury and the judge. The jury is the one that has to determine whether or not, beyond a reasonable doubt, okay, remember that, beyond a reasonable doubt, in a criminal trial, whether or not they find the defendant guilty or not guilty. Remember, it's not guilty or innocent because we don't necessarily know that they're innocent. We just know that there wasn't enough evidence to indict them. But yeah, they're the ones coming up. Do we believe that they're guilty or not guilty? That's the jury's decision, right? That's the verdict. The verdict is we, the jury, believe that the person is guilty or not guilty. All right? That's the jury's responsibility. The judge doesn't have any say in the verdict. The judge is important for the sentencing. The judge is the one that determines the sentencing for the offender. Remember those mitigating and aggravating factors. If we can remember that, mitigating being things that can weaken or lessen your sentence, and then aggravating things that worsen your sentence. So showing remorse for the victim would be a mitigating factor. Aggravating would be showing no remorse. All right, that's the judge's responsibility. Everything about the sentencing. They're supposed to interpret the law and say, based on the law, this sentence is the most suitable for you. Okay. All right. Second question. Let me activate the poll. What is the role of the Director of Public Prosecutions? To appoint defense barristers, to assign a judge to hear a case, to appoint a jury for a trial of an accused person, to review the charges against an accused person. What do we think? Give you guys a few minutes again. Okay, so far we have 100%. Oh, no, the mix is coming through. Okay, we still have a resounding main answer that people think. Process of elimination, people. Work backwards. Don't just pick the answer you think sounds good. Pick the worst answer, and then the second worst answer, the third worst answer, and check if that best answer is actually the best. Remember asking questions if you have any. So if there's anything I haven't broke down based off the last question, please ask me. All right, I'll give you like 2 more minutes. Cool. Okay. Actually, I think I might stop it now. All right. So most people said D. Some people said B. The answer is D. All right. And even if we didn't know that that was the answer, let's work backwards. As I was just saying, the process of elimination. Does the DPP, right, the Director of Public Prosecutions, do they actually appoint defense barristers? Well, no. The defense barrister represents the defendant, right, the person who is on trial, may be guilty or maybe not guilty. It is their responsibility to organize their own defense counsel. Remember, that's the terminology we like to use, defense counsel. In some cases, if they meet the test relevant, they can receive legal aid, but apart from that, it's their responsibility to organize their barristers, right, and their defense counsel. So no, it can't be A. To assign a judge, no, that has nothing to do with the DPP, okay? That's a Crown thing, that's a state thing. That's something that has nothing to do with the DPP, who we know is independent of the state, okay? It represents the state, but independent of the state. It can't appoint a jury because that would mean that they were biased. Because think about it, if you're the DPP and you're trying to convict someone of a crime, you're trying to prove that they're guilty, you're going to pick the jury that is going to most likely sway in your favor, okay? You're going to be biased. So it can't be C. So that leaves us with D. Well, let's have a read. To review the charges against an accused person. Well, yeah, they are reviewing the charges because they will then take the action to try and prosecute them, okay? So even if we didn't necessarily know that's the role of the DPP, just by simply working backwards, we can kind of ascertain that answer. All right. Which type of hearing establishes if there is a prima facie case? Appeal, committal, coronial, summary. Okay, interesting to see. Very interested to see the answers here. What do we think? Give you guys a few minutes. Oh, okay, we started to get some answers in. Okay, again, we have one resounding answer. That's good. We have a bit of a mix, though, between A, B, or A, C, and D. B seems to be the number one. Oh, not anymore. It's okay, no, it's still coming back. All right. Give you guys a few seconds. All right, I'm going to stop it there. So most of us said committal. That's true. This is just really memorization. Remember, a committal hearing isn't trying to find out if they're guilty or not guilty. It's really a judge and a DPP looking at it, well, magistrate, sorry, and a DPP looking at all the facts of the case and the evidence and saying, is there enough for a possible conviction? Could we actually convict this offender? Because if there's not enough for a conviction, there's no point in having a trial. It's a waste of money, it's a waste of time, it's a waste of effort, emotional effort. There's no point. All right, so prima facie, on the face of the evidence, okay, that's what that means, occurs, that process occurs during a committal hearing. Can we commit them? Can we actually find them guilty? Is there enough evidence that a jury would find them beyond reasonable doubt guilty of the crime? All right, next question. Which of the following can be used as a partial defense? Accident, insanity, necessity, self-defense. What do we think? All right, I'll wait for some answers. Oh, we're starting to get some. Bit of a mix. I think these are the ones that students always forget about. Okay, give you guys a few minutes. And I see the Q&As filling up with questions, so that's really good. All right. Okay. I might stop it here. Self-defense. Good. This is another kind of just simple memorization question. I will say, when you are studying the content in your revision, especially for crime, this area of the syllabus pay particular attention to, because they love to make multiple choice questions about this. What is a complete defense? What can reduce a sentence down from murder to manslaughter? What is a partial defense? All those, it's really good that you know the difference, okay? So I would, if I were you, maybe jot down on a sticky note or something, whatever, revise partial and complete defenses to a crime. That area of the syllabus, we definitely need to know. Okay, which of the following, this is our second last question. Which of the, our last question, I think. I can't move forward because I will tell you the answer. But which of the following is correct about a person's right to legal aid when on trial for a serious indictable offence? A, all accused persons have the right to legal aid. B, the right to legal aid is only available in the Supreme Court. C, defendants only have the right to legal aid if they plead guilty. D, a person has the right to legal aid if an injustice is likely to occur. What do we think? Give you guys a few minutes to answer that one as well. This is great practice, by the way, for crime, because these areas of the syllabus you obviously can't talk about in the extended response for your crime essay, can't really talk about the nature of crime. You're mostly going to be asked about it through multiple choice. Okay, so I would suggest doing these multiple choice questions as prep for when in your trials in HSC when you'll be asked about them. Because now, unless you, because I know some schools do human rights first and then crime, unless that's you, you will only ever be asked about crime again in the form of an exam. Okay, so it's important that you approach it that way. How are we going? Okay, most of us are saying A, followed by D. Cool, I'll give you guys a second to do that. Remember the Q&A. When we get into the content, when we start doing some revision, I would suggest to really have that Q&A up and remember to ask questions. Okay, cool. I'm going to stop that. Most of us said A or D. The answer is D, because it is not true that everyone has the right to legal aid. If I'm a millionaire, I wish I was, let's say I have, $28 million in the ideal world, I don't have the right to legal aid because it's unfair. There could be someone else who has very little money that can't afford to represent themselves in court, but I want the legal aid. Can you see how that might be an injustice? It's unfair that I would have the right to legal aid. So it's not a right, it's considered a privilege, okay? Not everyone just automatically gets the right to legal aid for a number of reasons. For example, that's one reason if you are above the wage threshold, if I make too much money, because remember, legal aid receives very little funding, which is something you could talk about in your essays. So they need to really prioritize who they're giving it to. They don't have, an abundance of public lawyers that they can just give out and say, all right, everyone gets legal aid. They need to prioritize the people with the lowest level of income that literally can't afford a barrister or a defense counsel of their own. As well as that, you will be denied legal aid if the evidence is very strongly not in your favor. For example, let's say I go rob a bank and there's the evidence of my fingerprints all over the crime scene, and they literally have the CCTV footage of my face in the bank robbing them. I will likely be denied legal aid because there's no point of legal aid. You're most likely going to be found guilty. Okay? The reason why we give legal aid, the number one reason, is if an injustice is likely to occur, okay? So Indigenous people, unfortunately, we know they suffer from injustices all the time. So Indigenous people are favoured for legal aid for that reason. We really, again, are prioritising. And that can transfer into a body paragraph, right? If you want to talk about legal aid for a body paragraph, those are many dot points that you can talk about, how it's effective because it prioritizes, but also it doesn't offer it to everyone, right? It's a privilege, not a right. It's considered a privilege, not a right. All right, last one then. Oh, okay, I have 10. I might skip through the next 3 because I do want to get to the content. This will be our last one. All right, a person, let me start the poll. A person is arrested for a serious crime. He exercises his right to remain silent before the trial. However, at his trial, he gives evidence that he was not at the crime scene. Which of the following is true? The judge can instruct the jury that this evidence may not be reliable. The prosecution cannot cross-examine the accused on this new evidence. The jury can ask the accused why he did not raise this evidence earlier. The accused does not have the right to raise this evidence during the trial. Again, if we're a bit stuck, process of elimination. Which seems the least plausible and what seems the most plausible? Oh, okay, we've got some answers flowing in. Nice. All right, bit of a mix on this one, bit of a mix. Okay. All right, I'll just wait until more people answer. Yeah, we've got a bit of a mix on this one. More of a mix than last time. Or in our last questions, I mean to say. But still, we have one resounding answer that everyone thinks. Okay, I'll give you a few more seconds. All right, let's stop it there. Okay, answer is A, and most of us said A. The reason why it's A is because anything that you don't say or do say can be held against you when you're arrested, okay? Everyone is really familiar with that phrase, anything you say may or may not be used against you in a court of law. That phrase means that, yes, anything you say, such as I committed the crime, can be used against you, but also anything you don't say can be used against you. So if all of a sudden you're justifying everything that happened and, oh, really, but it was just this and this was the actual truth that happened, the DPP can come and ask you, why didn't you say this at the time of arrest? Why is this suddenly coming up now? Is this something that could this be not completely factual? They can accuse you of that, stuff like that. So the judge has the right to instruct the jury that it may not be reliable because of that. All right, because it can be seen as something that's been made up after the fact. So